ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ ವಿಜಯ್ ಕುಮಾರ್. ಪ್ರೊಸೀಡಿಂಗ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆಯಾ?
ಇನ್ನ ಇಲ್ಲ ಸರ್.
ಇಲ್ವಾ? ಇಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೆ.
ಇನ್ನ ಇಲ್ಲ ಸರ್.
ವಿಜಯ್ ಕುಮಾರ್ ಸರ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಸರ್ ವೆದರ್ ಆಡಿಬಲ್ ಸರ್? ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್?
ಕೇಳಿಸ್ತಾ ಇದೆ ಮೇಡಮ್.
ಎಸ್ ಮೇಡಮ್.
Page wise adjournment. Page 10 from admission matter. 44 to 48.
Yes, what do you want, Prabhu?
Yes, my lord, serial number 44 MFA 1133 of 2020. I pray for a week's time, my lord.
Madam, already one person is submitting. Just wait for it.
Okay, sorry, madam.
You're deposited. Mahesh, inform Madi. That counsel for the appellant submits he has deposited the amount. Registry to verify. List this matter. When do you want? 2 weeks. Just after 2 weeks. Yes, madam. Anu Maria.
Yes, my lord. Serial number 44 MFA 1133 of 2020.
Yes, what do you want?
I pray for a week's time, my lord.
At request for crown counsel appellant just after a week.
Page 10, 49 to 53.
Serial number 53, my lord. Appearing for respondent number 1. Pray for 1 week time, my lord. Need to file objection, my lord.
I am for the appellant, my lord.
Objection to what?
I don't know what objection he is going to file.
Need to file objection.
ನೀವು ಅವ್ರಿಗೆ ಅವಕಾಶ ಕೊಟ್ಟರೆ ಅವರು ಹೇಳ್ತಾರೆ.
Please, my lord.
Yes, Mr. Karthik.
Pray for 1 week time, my lord.
For what?
Need to file objection
to what?
ಯಾವುದಕ್ಕೆ
objection ಆಗ್ತದೆ? What?
For appeal, my lord.
You're appearing for the first time. What?
Please, my lord.
You're Karthik?
Karthik is my senior, my lord.
Bring him. This is final hearing matter. Bring him. And the insurance appeal, Vijay Kumar?
Also.
All right, you bring him. Next. Yes. You have to be audible, sir.
Number 1, Manohar DK.
Manohar. Week's time granted to comply.
Number 2, Varatnath.
Dwarkanathan Re. Sir. Maintainability. This has to come as commercial appeal. Now you have filed MFA. Agreed by what order? arbitration suit. What is the order? Is it an interim order or just main? What do you want now? What do you want? Where is the order sheet? Purple. There are council. Submits that the impugned order arises out of judgment passed by the commercial court in commercial AS number 2 of 2015. By mistake, it is styled in the nomenclature as MFA, whereas it should have been commercial appeal. Correct? The council is permitted to carry out the necessary corrections and classify this MFA as commercial appeal. Week's time is granted. Random appeals consisted. All random appeals are today. This first list. Yes, Narasimha Prasad. Disposed of for statistical purposes. This matter is disposed. CPC, non-compliance. What is the order is challenging? What is the compliance? What is the non-compliance? Now that he is here, what is that is a service of compliance service. What are you challenging? Boundaries of Schedule B property to be stated correctly. Acknowledgement having served. Huh? What are you challenging? Order 39. What happened? You are suit for? You're ready? Topic body. You who are you? Plaintiff. You secured interim order of injunction 39(1) and 2. Then he has to be heard, right? Just because you secure an order, you cannot just take your own sweet time. You have to justify that, get ready, argue the matter, be listed next week. Then at counsel for the appellant to serve a copy on the caveator respondent. Only the one respondent? Caveator respondent. Release this matter next week. If office objections are complied, list this matter on 13th. 13th. Comply. That is one objection raised.
My lord, I appear for the cross objector in that matter, my lord.
Madam, yeah, I think you're offering the wrong matter. We are calling out serial number 1 in the first list.
I'm sorry, madam.
Yes.
One paper to be replaced.
Huh? Court fee to be paid. You paid. When did you pay?
Today morning, because they raised the objection. Today morning.
Fact sheet to be stitched for IA. Schedule detail to be stated in IA.
Yes, and only the one paper to be. Because there is an urgency.
What is the matter?
The suit for injunction was filed before the trial court. The order of status quo was granted initially.
Who are you?
I am the plaintiff before the trial court. Injunction was granted initially, directing the parties to maintain status. I have produced all the registered documents, undisputed registered statement produced before the court. I am status quo was granted.
Suit for what, sir?
Suit for injunction. The defendant appeared before the court. They produced a certain revenue documents in spite of the judgment of the Supreme Court which are cited before the trial court. That the revenue documents cannot be considered as title documents.
Court officer, unable to see the court.
What of sir?
ಡಿಸ್ಕನೆಕ್ಟ್ ಆದ ಕಾಣಿಸ್ತಾ ಇದೆ ಕೋರ್ಟ್ ಕನೆಕ್ಷನ್.
ಎಲ್ಲಾ ಕೋರ್ಟ್ದು ಆಗಿದೆ.
Undisputed statement.
All right.
And thereafter I have produced the.
Is it empty? What is the suit schedule property?
The suit schedule property is a land lot measuring about 15 guntas.
18 guntas vacant
18
land.
guntas out of that.
6 guntas kharab land. All right, it is an agricultural land
No, not agricultural land. Now it was converted into sites.
located in Kengeri.
Again,
All right, it's a vacant empty land.
yes,
Yes, what is the document you have produced? Sale deed.
sale deed, my lord.
Ah,
Sale deed I have produced and the latest RTC.
yes. Now what is happening?
Now, my lord, the defendant, the respondent before my lord, now he is, the moment the order of the status quo was dictated, he is dumping, bringing on the order to,
All right, come to the discussions.
no, your lordship kindly take.
What is the stand of defendant?
The defendant stand, my lord, even I am very surprised, the learned president just taken into consideration all the revenue documents which was produced. Only the revenue document, the rest of the statement which he has produced, my lord, with the entire statement nowhere stated as to how their predecessor in fact acquired the property. But just there is a mention absolute bonus.
Yaro.
The respondent predecessor. The statement which was executed in favor of the respondent. The learned, the predecessor in fact, she says in the statement that she is the absolute owner. That's all. As to how she is the absolute owner, how she acquired the property, not a single word in the entire statement. Your lordship kindly see the learned trial there has taken into consideration only the revenue documents.
How does the defendant get title, sir?
The
Or owner?
defendant, he says that he acquired the property
From
under
whom?
a registered sale deed.
From whom?
From one, Your Lordship, this is the documents which they have produced. And one from Borama.
Who is she? Wife
The
of?
whole the problem is.
Who is she? Wife of?
She is the wife of Govindaya.
Ah.
And now that Borama, Your Lordship, this is one Bhagyama, she says that she acquired the property and the register sale date dated 1992. They have produced that sale deed before the court. Now, my Lord, Your Lordship kindly say that in the entire sale deed, it was stated that it is the self-acquired property of one Timaya. But how it is self-acquired property, nowhere it is mentioned. All created bogus documents. Your Lordship kindly take the judicial note in the entire category. Almost all this land grabbers and another sale deed he has produced, my Lord. That in that sale deed, Your Lordship kindly say that is dated 15/3/2011. One Bhagyam was sold to the respondent hearing.
Recorded. Third, Learned Counsel Sri Muhammad Nasiruddin on behalf of appellant plaintiffs. Issued emergent notice to respondent defendant. IA number 1 of 2022 will be considered after service of notice to defendant. Release this matter next week.
Because he has already dumped the building.
He has already dumped and he has been constructing building. Yes.
That's what I am submitting.
How can this court decide?
I only submission.
You are not clear. You have not come before the court with clean hands. You have not stated about the sale deeds you made to Sumanda Jain, to Rame Gowda. That is what the trial court has held.
All that.
You consider.
I only submission like the parties.
No, sorry.
Otherwise, the whole suit and the.
It come up one more. Nothing will happen. If you have made out a case, we will restore your position back. We'll restrain him. If you make out a case, we will restrain him from conducting any further activities in the suit scheduled property. You satisfy? Madi. No, sorry. It is an injunction matter. Why the matter should stop in the trial court? Sorry, sir. You take out notice, serve him, learned counsel, learned counsel for the appellant is also permitted to serve a copy of this appeal to the counsel on record before the trial court. Counsel for the respondent, defendant on record before the trial court. Release this matter next week. Kundanwara. Aurgu ಸ್ವಲ್ಪ time ಕೊಡಿ Monday. Released on 12th. Yes, sure. 12/4. Call it out. I'll tell you. But it should go according to the list. Gangadarappa, Muddappa. You're for your Muddappa. Where is Gangadarappa? All right. The judgment is ready. I think taking a small corrections. We'll call it out at around 12:30. Both of you can be here by around 12:30. You go wherever you want. It is your choice. Can I restrain you? You're free man. You can go anywhere, wherever you want. Court will pronounce at around 12:30 because there are some slight corrections brought to my notice in the morning. Yes.
Orders, serial number 2.
Pujari is not well or what? He's not coming. Week's time granted. If needful done, issue notice to R2. What is he challenging? 50%. So we'll release 50% of 50%. Keshav Prasad? Yaro? Keshav Prasad. What are the other objections? Or R3? Co-claimant. Why you made her as R3? All right, if PF paid within a week's time, if needful done within a week's time, issue notice to R3. In the next matter, she is served. Served. Yaru. No, served but not represented. Here you have to take out notice. Keshav Prasad. So amount is deposited before this court. Third Learned Counsel, Sri Ravi Shankar Shastri, who is the appellant in the first case and respondent 1 to 3 in the respondents 1 to 3 bar 1 to 3 bar claimants in the second case. The memo is filed seeking withdrawal of the amount in deposit made by the insurance company before this court. Admittedly, 50% of the award amount has been deposited before this court by the insurer. The appellants, the claimants are the legal heirs and dependents of the deceased. In view of the challenge made by the insurance company with regard to the liability of 50% to be attributed to the claimant himself, deceased, who was driving a jeep. I deem it appropriate to order for release of 50% of the amount in deposit in favor of the claimants 1 to 3. To stop. There is a apportionment. To the claimant number 1, who is the guardian of claimants number 2 and 3, being the minors. The amount, accordingly, the registry of this court is directed to release 50% of the amount in deposit to the claimant number 1 in accordance to the proportion stipulated by the tribunal. All right. Why you give it here? Give the bank details here. Stop on the Learned Counsel for the claimants furnishing the required necessary bank details, including account number, IFSC code, and other details. Registry to disperse and release the amount accordingly upon proper verification. Immediately issue notice to R5. Yeah, the unclaimed. Yaro? R5 is she is served. All right, we'll see, because they may come, somebody may represent them. If they don't, then we'll see.
IPF.
Yaudrelli. Who's the second respondent? Liability is on ಯಾರ ಮೇಲಿದೆ? So R2 is required. So you take out notice. Insufficient address. Purple. Third learned counsel for the appellant. Each time for the learned counsel to serve copy of this appeal to the learned counsel who had represented the respondent number 2 before the tribunal. Yes, Madam Kalpana.
In cross objection, my lord, Ravish Benny may be ordered to be taken, my lord.
Which respondent?
First respondent, my lord.
Learned counsel Sri Ravish Benny, who's appearing for the insurance company, is and also preferred an appeal, is directed to accept notice for respondent number 1 in MFA Crop 63 of 2019.
Insofar as respondent number 2, my lord, the same order may be passed in my case also, my lord.
I passed for R2 in the connected learned counsel to take out notice for counsel on record for R2. First order madadvalla same. Yes. Non-compliance both time. Acceptance. Your respondent 1. No notice was issued. Huh? Wakalat filed by Sri Learned Counsel Sri G.S. Marulaya for R1 is accepted. Who is this counselor? Santosh BL? In claimant's appeal. You are appearing for? Have you seen the papers? What happened to the petition? Allowed or what? Enhancement? Paper odilvenre. You have not read the paper? Not given. What is being challenged? Is it dismissal or is it enhancement? Hardly allowed. 1 lakh. This is value of appeal. Recording. While order dated 3/3/2022, this court granted 2 weeks' time as a final opportunity to the appellant to rectify and comply with the objections raised by the registry. Despite giving sufficient opportunity earlier also, the rectification of office objections have not been complied. However, providing one more opportunity, 2 weeks' time finally is granted to comply with the objections raised by the registry. If the same is not complied within 2 weeks, the appeal shall be dismissed for non-prosecution without reference to bench. Peremptory order is made accordingly.
I'm for appellant in this case, my lord. Non-compliance of office objection is that next date al ಮಾಡ್ತೀನಿ.
Weeks time granted to comply.
Much obliged.
Let I appear for the appellant. Shri A. N. Krishnaswamy may kindly be directed to appear for R2, my lord. I have spoken to him yesterday. he said he will appear for Oriental Insurance Company, R2, my lord. A.N.
Is it
Krishna
for the
Swami.
first time or second time?
No, no, but A.N. Krishna Swami said, my lord, he is appearing, he will appear for Oriental Insurance Company, R2, my lord.
First time
I
or
will-
second? Two left, all right. Recording. Learned Counsel Sri Somashekar appearing for the appellant submits that despite service of notice once, the Shara is returned as addressee left on behalf of the insurance company. Learned Counsel Sri A. N. Krishna Swami, who is the counsel on panel of the insurance company, is directed to take notice on behalf of respondent number 2 to show his name in the cost list. Do they know whose appeal is this?
Tata Coffee, the employer, my lord. Only regarding interest and medical expenses
Yes.
and reimbursement of the amount deposited by us.
You have deposited the entire amount?
We had deposited, but the insurance company is made liable, and there is a direction for the insurance company to refund the amount deposited by us, my lord, which was
So
not.
now you have
done.
deposited the entire amount.
Okay, I mean, 3/4 of the amount, my lord.
What do you want? What else you want now?
Interest and other things, my lord. Anyhow, I serve a copy to Krishna Swami, my lord. When he once comes on record, it could be decided, my lord.
Execution hakidara.
I don't know, my lord.
So they will straight away go and withdraw there. Allah.
No, there's a direction in the order. You last may kindly see at page 27, ink page 27, my lord.
Yes, yes, I'm having.
3,11,000 is there, but and then the last sentence in that first paragraph, and directed to indemnify is 2,60,000, which is already deposited to respondent number 1. That is Tata Coffee, my lord, employer. This amount I am requesting for. Therefore, it could be resolved, my lord, once A.N. Krishna Swami appears.
All right.
Much obliged.
We'll discuss next week.
Please, my lord.
Number 8, A. Vijay Kumar.
I am for the appellant, my lord. My lord, take steps, my lord, proper steps, my lord.
Week's time granted. Needful done. Issue 1 and 5.
In the next matter, my lord. In the
Yes.
next matter, this matter is connected with MFA 6270/19.
Registry to this appeal along with MFA 6270/19.
Please, my lord.
Yes, my lord. My lord.
My lord, I am for the respondent, my lord.
Vijay Kumar. Next.
Can you continue with the reading?
Week's time granted. Comply.
Swami P. Case number 4.
No liability on R2. Copy bandila. Huh? Any liability on R2? Who's R2? Notice to respondent number 2 is dispensed. There's no liability fastened. Orders on IE1. IE1 allowed 142 days condoned in filing the appeal. However, no interest for the delayed period. Claimant Allah? Huh? 19. Registry to list MFA 7411 of 19 along with this appeal. That is preferred by another claimant. आगे दिया.
My lord, I am for the respondent, my lord. IFCO Tokyo Insurance Company.
Yes.
Delay may be condoned without
One
interest.
ನಿಮಿಷ ವಿಜಯ್ ಕುಮಾರ್ ಅವ್ರಿಗೂ ಸ್ವಲ್ಪ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋ ಚಾನ್ಸ್ ಕೊಡಿ. Claimant's appeal. 7430/19. registry to list MFA 7430/19 along with this appeal. Yar file madradu? Filed by another claimant. Filed by another claimant arising of the same accident. Yes, what else you want? No liability. No liability, Vijay Kumar, 1 and 2.
There's no liability.
Notice to respondents 1 and 2 is dispensed with as there's no liability. Yes, next, what else? That's all. What about your IA? Delay condone madad bedwa? Yen madbeku? Why? Why delay should be condoned? Orders on IA1. IA1 allowed. Delay of 217 days condoned. However, on appellant being successful shall not be entitled to interest for the delayed period. Yes.
Serial number 13, my lord. Claimant appeal, my lord. R1 no liability, my lord.
Notice to R1 dispense.
Notice for R2, my lord.
Okay.
I will take
Pradeep.
notice, my lord.
Yaro, Vijay Kumar.
Yes, my lord.
The counsel say D. Vijay Kumar, who's present through VC, accepts notice on behalf of respondent number 2, registry to show his name, the cost list. Notice to respondent number 1 dispensed with as no liability is fastened. Orders on IA1. IA1 allowed. Delay of 1 day condoned. Learned counsel to furnish a copy to learned counsel for respondent number 2. Harita.
My lord, appear for appellant, my lord. My lord, all to if court okay served unrepresented, my lord. Pradeep may be directed to take notice, my lord.
Why only Pradeep? We will
Anybody,
direct-
I leave it to court. I leave it to the court, my lord. And there is a delay of 39 days delay, my lord.
Learned counsel say Pradeep B accepts notice on who's present before the court accepts notice on behalf of respondent number 2, registry to show his name in the cost list as counsel for R2. Notice to respondent number 1 is dispensed as no liability is fastened. Orders on IA1. 1 allowed. 39 days condoned. Copy kodi avarge.
Please, my lord, I will. Obliged.
Sign granted if needful done. Registry to issue notice to R5. What is this 4th time? And next time grant to take necessary steps. You want substitute service, then that has to be allowed. Whatever you want to file, you can file. 3. The claimants. ಯಾರು appear ಆಗ್ತಿದೆ? For whom are you appearing, my friend? Who are your clients? Who are your clients? ಏನಾಗಿದ್ರು ಅವರು? ಏನವರು? ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿನ? ಓನರ್? Petitioners in the lower court ಏನವರು? Who are they? Death case or injury case? ನೋಡಿಲ್ಲ? How old you are in the bar? 2 months. Okay, good. Next time you read and come. What about connected matter, madam? You have filed also connected matter MFA crop. Adರಲ್ಲಿ you have to accept note. Who are you? Respondent number. Now he will give. You will make you give. Make him give you. Which is what are you in the MFA crop? Open madi. You have to say. Can't just stand here. Name the New Indiana National Insurance. New National Insurance. All right. Learned counsel Sri Manjula N. Tejasvi accepts notice on behalf of respondent number 4. Issue notice to respondents, other respondents. Learned counsel for the claimants to furnish one set of copy to learned counsel for respondent number 4. Each time granted to do the needful. 2 weeks time granted to needful, if needful done, issue notice to R2.
I appear for appellant, my lord. I pray for short date, my lord, for complying with the office objection.
You copy kottilla.
The process memo, my lord, there appears to be some office objection.
No, now that Pradeep has filed, has come on record,
I'll serve the copy on email.
weeks time granted to do the needful.
Much obliged.
R1 and R2 liability on them. At request of learned counsel for the appellant, the for dispensation is dismissed as withdrawn. Then they have to come on record, issue notice to respondents 1 and 2. Really? Registry to solve this matter along with MFA 024 of 19 and 2 other matters. Shastri?
No, my lord. My lord, I am for
second respond.
My lord,
Liability on R1, Patil?
no liability, only on insurance.
Respondent number 1 dispense as no liability is fastened.
Delay may be condoned.
A1 allowed. Delay of 54 days in filing appeal condoned. Copy bandidiya nimage?
Next on the same.
Next week records sir.
Next also same.
Next also same.
Notice to respondent number 1 dispense as no liability. IA1 allowed. Delay of 54 days condoned in filing the appeal. Registry to secure TCR. Yes, agree.
My lord, I appear for the appellant, my lord. Sorry, respondent, my lord.
Madam
Delay may
Nazifa.
kindly-
No liability on R1. Agree.
Well, serial number 21, my lord, we have
21.
accepted. Yes, my lord, we have accepted the liability. That case, it can be even
Notice to
disposed of.
respondent number 1 dispense as no liability is fastened.
Delay may kindly be condoned, my lord.
Are you ready in the matter?
Yes, I am ready, my lord. I even calculated the amount, my lord.
So there's some marginal enhancement.
Yes, my lord. Yes, my lord.
All right, then we'll call out, madam. You have to wait. Work on it. Orders on IA1. IA1 allowed 141 days in filing the appeal is condoned. Pass over.
Problem.
Notice to R1 dispense as no liability. Orders on IA1. IA1 allowed. IA1 allowed 223 days in filing appeal is condoned. No interest for delayed period. Registry to secure trial court. R1 yaru. No liability. No liability. Notice to R1 dispensed as no liability is fastened. Orders on IA1. 1 allowed 151 days in filing appeal condoned. No interest for delayed period. Abdul Sabur. Any liability on 1 and 2? Notice to R1 and 2 dispense as no liability is fastened. IA1 allowed 33 days in condoned. Delay. National Insurance Company.
Well, I can take notice, my lord. I can.
CSV Hegde, who is present before the court, accepts notice on behalf of respondent number 2, registry to show his name. Notice to R1 dispense as no liability is fastened. Notice on IA1 allowed 31 days delay condoned. Next. Keshav Prasad.
Yes, my lord. For the respondent, the delay may be condoned.
No liability. Notice to R1 dispense as no liability. Orders on IA1. IA1 allowed 397 days is condoned filing the appeal. However, no interest for delayed period.
Maybe refer to local.
At request of both learned counsel, matters referred to Lok Adalat for resolution of dispute.
Please.
No liability. R1 dispensed. I1 allowed. 273 days condoned. No interest. Mahadev Swami. Both same, same order, madam. Same order. Same order. Your name is Mahadev Swami? Both are same accident. Registry to list MFA 3549 along with MFA 3554 of 2020. Next week.
Number 29. Here is my HR.
You're here. I was looking there. You are sitting there. Judgment of tribunal. Yes.
By showing the amounts
47.
Page, the judgment page 41. That's the next page. Monthly, instead of showing 227. So that will not repeat. In fact, I verified this in the office for 2 years.
Has it got interchanged? No. 3813, 2,37,000 Agbekagi. What is our? Huh?
So 2068, 4,03,000.
The interchange agide.
But award is correct.
So this is the objection.
The difference is that stated as award at the various heads and already
Why didn't you make a reply to that?
I explained the Lord explained to them. I made a note. The Lordship says not all the objections don't make it. I'm valid it. In fact, I myself went to the office. The Lord explained. I wrote also, but it's the copy of the note. I mean, even though the valuations people look the valuations people
Third learned counsel for the appellate insurer, KSRTC. The objections raised by the registries with regard to the amount mentioned in what are the objections raised? Mentioned as under various heads, amount of compensation as 2,37,000. The operative of the judgment it is shown as 4,03,000. Learned counsel for the appellant has given an explanation note to that effect by stating that since there were two cases, claim petitions, the amount the amount awarded has been interchanged to to the respective claim petitions. It is a mistake and an error committed by the tribunal, and it has got nothing to do with the appellant. Therefore, these objections raised by the office is overruled. Yes. Other number 5185. Registry to list MFA 5185 of 20 preferred by even. All right. 5185/20 along with this appeal will stop. Issue notice to the respondent. Any other objections? Any other objections?
They already in fact, the opponent apply with the
Orders on IA1 of 2020. There shall be stay of operation of execution of judgment and award dated 25/2/2020 in MBC 3813 of 18 passed by MACT Bengaluru within bracket SCCH2, subject to the condition that the appellant herein deposits 50% of the award amount. Award also ideyala? Award shows 237. %50 of 2,37,000.
This case I am for the appellant, my lord.
Award of 2,37,000 within a period of 4 weeks. Before no, why?
So that means they have deposited already before I file the report to them.
All right. Within a period of 4 weeks. Venkatesh.
In this case, I am for the appellant, my lord.
Yes.
Time for
Huh?
steps. Taking steps, waste time.
2 weeks time grant. If needful done, issue notice to R1 to 4. Krishna Swami. Issue emergent notice. R2. Second time. ಯಾರು ಮಾಡಿದ್ದಾರೆ ಆರ್ಡರ್? Weeks time granted if needful done, issue notice to R2. Same order, next matter. Same order. 33, same order. Weeks time granted to comply. Venkatesh.
My lord.
Ive Venkatesh, huh?
No, my lord. Venkatesh Kamath.
Ilri, the AM Venkatesh.
Sorry,
AM Venkatesh and the Lakshmi Narsappa, Lakshmi Narsaya. Narsappa. Lakshmi Narsappa. All right. No representation on behalf of appellant. Release next week. 37 and 35 and Ilri, we are in 35 now. 47, madam, even 47. No representation. Call this matter next week. Nagaraj. Weeks time granted. Comply. Acceptance of office note on limitation. Their order sheet. No representation, release next week. ಯಾರಿದು ಮಂಜುನಾಥ್ ND? Who's this counsel?
My lord, he has appeared before the court today.
But that is not
before the court.
his colleague. He is Manjunath. Orders heard, learned counsel. Orders on IA1. IA1 is allowed delay of 67 days in filing appeal is condoned. Claimant's appeal, you know. However, claimant will not be entitled to interest for delayed period. What is here low fee? Liability only policy. Madam, here this is on interlocutory applications. You are before this court for this IA for today. Who are you? First owner. So now your case is you have sold the vehicle to Lata.
Subsequently, what happens? Lata's husband, the subsequent owner's husband, her brother-in-law, we both take the vehicle and leave the accident. The police, after verification, with serve a notice to Lata as the owner of the vehicle. This Lata gives all the documents to the police and then releases the vehicle to the identity of everything. I could not release the delivery and the identity. So I have produced it here. That also notices given to Lata. Even exhibit E5, you see the document owner is Lata. That is a subsequent owner. Hence, what I want to do is I want to include this lady Lata, subsequent owner. It is her husband who has gone and did an accident. Her husband and the brother-in-law. Brother-in-law is injured and he has come as a party. Exhibit E5 also can be seen. Here also, column number 8. Name and address of the owner of the vehicle and the type of accident.
What has the tribunal done?
The tribunal has said, you are the owner of the vehicle. Whom you have sold the vehicle. You are the owner, hence you are liable. My contention is, everywhere the records show that she was the owner of the vehicle. And even the complaint is written by her husband, Dinesh.
Then why didn't you seek? Why didn't you seek for this impediment before the tribunal? Did you file an IA? Where is that mentioned in the? Where?
In page 11. Page 11. The second, paragraph 14. The second is called my name, Ganesh Kumar is taken and the key is also legal. One Lata, the date of the accident, is not the owner of the respondent to examine started to work and put his two documents after exhibit R, the respondent is the respondent. So the later on taking the Lata case in the promise declared that she purchased the vehicle. The respondent said so the later on.
When did the accident happen?
24 2000. the date of accident, the RC stands as 8 precedence. We extract the parties.
You have stated that you have sold the vehicle on 1811.
My only contention is that you keep the car and I may be going to cross examine.
At first, you have to make out a case for impediment. All your other things will follow later. Respondent number 2 himself has stated that he sold the vehicle on 18/11/2015. RC is not changed. No, RC. So RC is in whose name? Your name.
Because of holidays, the holidays and was Dasara vacation.
Henry, ಬೇಕಾಗುತ್ತಾ?
No liability.
Liability is fastened on her. There is a claimant served and unrepresented. All right, Parkoli. Remand will come later, madam. You are jumping too many guns. You have to go step by step. You have to first convince the court. If the court is satisfied, then it will allow your appeal and whether remand or not. This is last stage. If first stage, last stage go good. This orders on IA 2 of 19. Notice ಹೋಗ್ಬೇಕಲ್ರಿ ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ. Issue notice on IA number 2. Lata KS ಏನೋ R3 served ಅಂತ ಇದೆಯಲ್ಲ. Notice is served. Huh? You have taken out notice through court and served. What do you? In view of notice for the orders on IA 2 of 19. In view of notice having been served on the proposed respondent number 3. Namely, Sri Lata KS and her name having been shown in the cost list as served, there is no representation. Her name is called out and there is no representation on her behalf. Stop. We have the same. The application filed to implead Srimati Lata KS as respondent number 3 is allowed. Accordingly, learned counsel for the appellant to carry out the necessary amendments in the appeal memo. IA 1 of 2022 for production of additional documents will be considered along with the main copy of the IA to be served to the other side. Kottidara? Carry out the amendment. IA1. Third. Delay ಇದೆಯಲ್ಲ issue notice on IA1. Sachin. You're the owner. Liability is on you. Production. Your file production. Production of the document your file. All right, we'll consider that. Await service of notice of R1 to 4. Stay ಇದೆಯಲ್ರಿ? Why is the stay limited? Stay was granted. 6 weeks. You have deposited. Page number of four. ಇಲ್ರಿ 36 ಪೇಜ್ ಏನೇ ಇಲ್ಲ. Only in your records, not in court record. ಇದೇನಿದೆ? What is the award amount? This is 25,000. $11 lakhs, 87,000, 6% interest. Petition is dismissed against R2. R2 is insurance. You're R1. You're the owner, driver and owner. So liability is on you to pay 11,87,000. You are not deposited. 25,000 ನೀವು ತೋರಿಸ್ತಾ ಇರೋದು. What is your name? Matukeshwar. You ತೋರಿಸ್ತಾ ಇರೋದು 25,000 deposit. So you are not directed to deposit any amount. Bruce affidavit, being satisfied, posture, application allowed, stay of improved judgment and award. This death case entry, execution hakidara. They are not deposited, no order to deposit also. Barkoli. Wide order dated, third learned counsel for the appellant. Wide order dated 1/10/2021. This court granted stay of judgment and award dated 9/2/2021 passed by MACT Madikeri in MVC number 164 of 18 for a period of 6 weeks. A notice came to be issued to respondents. Full stop. Notice is not yet served to respondents 1 to 4. However, there is no order made with regard to deposit of any amount. Liability being fastened on the appellant, owner and driver of the offending vehicle. In view of the same, I direct the appellant herein to deposit 50% of the award amount within a period of 4 weeks before the MACT. Four weeks before the MACT, on deposit of the said 50% of the amount, the order of stay shall be operative till further orders. According to you, liability is on the insurer. You produced the policy. That has to be considered. So if that is correct, then we will order for refund. The liability will be taken over by the insurance company. That is your case. Manjula. Quantum will release. Yesterday ನೀವು ಡೆಪಾಸಿಟ್ ವಿಡ್ರಾವಲ್ ಕೇಳ್ತಿರೋದು ನಾಯಕ್ರೆ. All right. %30 out of 50. Right? Have we done the calculation? Have we done the calculation? Salary certificate exhibit P13. What is that tribunal taken? 20. So that is double of the notional income. Have we examined? Yarna? Madidira?
Also admits that they have not produced the entire master road. They have not given service register of all the employees. And what they claim that they have produced services register. It pertains to only one. This is the road. This is only there. What about the other employees who are working in the company? That is not a register. And audit funds given their audit report here. Bank person get a bank pass. This is the PM. Sometimes we even used to get cash after a more than 20,000 cash. Now, often there is the capacity to produce. Now, nothing is on record here.
Madam, in several companies, in order to avoid payment of PF, gratuity, and all these statutory payments, the company will not have all this. Only for the purpose of evading the tax and other. Maybe not, but that madam, that will draw adverse inference on them for attracting penalty and other consequences under other laws. The claimant is nowhere concerned with the company fault. Third learned counsel. Yes, your contention is accepted. Third learned counsel Srimati Manjula Tejasvi for the appellant owner anivu appellant insurer, and learned counsel for the respondent number 1 claimant, 1 and 2 claimants Orders on IA number 1 of 2022. This application is preferred by the respondents bar claimants seeking withdrawal of the amount in deposit made by the insurer, appellant insurer. Admittedly, 50% of the amount has been deposited by the insurance company before the tribunal. Full stop. The challenge in this appeal against the impugned order by the insurer is with regard to the quantum awarded by the tribunal and the veracity of the document exhibit P13, P13, 15, which are the salary slips and the very aspect of the deceased being employed in the said company bar firm. Firm or company? Na? Company and you know the difference between company and firm. Bar entity and company under Companies Act, firm under the Societies and Firms Act. Hence, in view of the deposit having been made to the extent of 50%, though the quantum is challenged, I do not find any legal impediment in awarding or granting, in allowing the IA. Hence, IA is partly allowed. 50% of the amount in deposit is ordered to be released in favor of the claimants, respondents number 1 and 2 claimants, upon proper verification. Particular bank details, trial court will deposit. The tribunal is directed to release 50% of the amount in deposit made by the insurance company in favor of the respondents 1 and 2 bar claimants. Registry to secure trial court records. Avoid service of notice to R3. Yaro R3? Liability is on? R3 is the owner. So now the liability is on you. So you need R3. Await notice of R3. Yes. What else? Filed by you. Filed by you. Registry to list MFA 5426/21 preferred by the claimant seeking enhancement. Along with this appeal. Should notice. Admission. Serial number? Yes, Mr. Hegde, you are ready?
Yes, my lord, I am ready, my lord.
Pavan Chandra Shetty. Madam Nazifa. When she comes again.
Madam, number 44 urgent, 45 urgent, 46 13 PS, PD urgent for auto.
Okay. Any instructions about Tira? You are ready? Huh?
Hello. Namaskara, Gauda.
That means you are not ready. Ready? Vijay Kumar, you have to mute your mic, Vijay Kumar.
Hello, 1 minute. Please, my lord.
You have to mute your mic, sir. You speak whatever you want.
I'm sorry.
Nodilla, file nodilla. All right, when do you want? Next week? Your claimant, Allah, seeking enhancement. Dismiss agidi. All right, we'll grant him. Week's time? at request of learned counsel for appellant released next week. Mail ಬಂದಿದ್ಯಾ? Papers ಕೊಟ್ಟಿದ್ದಾರಾ? Both same connected. Who's Prakash? Prakacha, let's see. There's no representation on behalf of appellant. Release this matter. Have a great week after next. Week after next. Copies received. Registry to list this matter along with MFA 1289 of 2022 arising out of the same accident. Suma, Char Renuka. Itra Lavagla, Suma under KD Lia Sumana, KD Laya. Abagla Itrala. Pavan, you're ready. Yes. No problem. Hegdeji.
Yes, my lord. Ready, my lord.
Yes, your friend has graced this court.
Yes, I informed them about this, my lord.
Yes, after making you wait and this court wait, he has arrived in full speed. Yes.
We are obliged, my lord.
Ready, Madidara Hegdeji?
Yes, my lord, I calculated, my lord, 9,000 has been taken. My lord, for the year 2018, it is 12,500. 40% is to be added, 17 multiplier, my lord. It will amount to
less than 40.
17 lakh.
Death case, you know?
Death case.
So 2018. What has been taken? Santa Pujari. Let's come to the judgment. Where is the discussion of income? Is so 9,000 is taken as income. Huh? Yes, 9,000 is. It should be 12,500.
12,500.
Plus 40%. That is already awarded.
Yes.
So that's correct. So divided by 50% is also correct.
50% is to be deducted. So it will amount to 17.
Multiplier is 17 or 18?
17, my lord. 30 years.
Age is 13, huh?
30 years.
All right. So everything else is right. And what is next? Come to page 17, internal page 12. Loss of love and affection. What does it say? Para number? Body.
And compensation for loss of consortium, the NFC is 40,000 per client. So that we have got EA. Now, what is the the present status of the what it is considered by law is considered per head. Bifurcated and consider as it is independent. Outsourcing is independent and low end capacity is independent. Per head may not considered according to 50,000 for low end per climate and may not 20,000 per climate as a consumption. So that may not I want to assist you to I'm giving to the law.
Mr. Hegde,
Very recently.
maybe, sir.
My lord, this regarding
Were you able to hear the argument?
yeah, I couldn't follow what he was submitting, but my lord, the controversies, I think, my lord, regarding this conventional heads. Conventional heads, my lord, 40,000 each, mother and father and mother are entitled, 40,000 each. Then, my lord, this last to estate 15,000, my lord. Totally, it will amount to 1,10,000. My lord, that can be recalculated and awarded, my lord.
Now, what Mr. Counsel for Appellant is submitting is relying on the judgment of Delhi High Court Division Bench, where
Yes,
they have
my lord.
awarded, apart from 40,000 per head, 50,000 per head for loss of love and affection. He wants to rely on that judgment to
My lord,
separately award compensation under the head love and affection.
My lord, Supreme Court in Magma General Insurance Company made it very clear. Facts of that case may be different, but Magma General Company Insurance Company case and even Pranay Sethi case also, my lord, in order to maintain the uniformity, court cannot to go, my lord, certain things, my lord, and only this, my lord, it used to be as a thumb rule, it is to be, my lord, followed. Accordingly, my lord, Magma Insurance Company, it has been, principle has been generally accepted and followed, and it was not challenged, my lord. Even Supreme Court has also in the recent judgment, 40,000 each has been awarded. So
Yes.
that's why, my lord, the Delhi High Court judgment may not be applicable to the facts of this case, my lord. And for the purpose of present case, my lord, Magma
What is the
General
effect
Insurance
of this
Company case,
judgment on this court?
my lord, Delhi High Court judgment, my lord, is not binding on this honorable court, my lord. And
That's all.
context may be different.
That's all. Yes.
Only in, my lord, the Supreme Court in categorical terms held 40,000 each.
Yes.
And in Lok Adat also, my lord, we are following the
This
same
appeal
thing,
is
my lord.
preferred by the claimant seeking, aggrieved by the judgment and award of senior civil judge and MACT Karkala in MVC number 1097 of 2018, dated 28 March 2019. Appeal is founded on the premise of inadequacy of compensation. Kutkod.
My lord, interest must be 8% has been awarded. It may kindly be 6% on the enhanced compensation.
Yes. ನೀವು ಅಪೀಲ್ ಹಾಕಿದ್ರೆ ಅದನ್ನು ರೆಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ.
But usually, my lord, this honorable court is, my lord, in all cases uniformly granting 6%.
Correct. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ನೀವು ಅಪೀಲ್ ಹಾಕಿದ್ರೆ ಅದನ್ನು ರೆಡ್ಯೂಸ್
ನಾವು
ಮಾಡಿ.
appeal ಹಾಕೊಂಡ್ಬಿಟ್ರೆ ಮತ್ತೆ unnecessary this proceedings will be protracted.
On 19/5/2018,
Only just compensation.
4:55 p.m. One Vasanta Pujari was riding his Bajaj Discover two-wheeler bearing registration number KA20EC 0779 from Kadthala towards Ajekar, and when his two-wheeler reached near Shiribailu of Kadthala village, at that time one light goods vehicle van bearing registration number KA20B1030 came in a high speed in a rash and negligent manner so as to endanger human life and safety, and dashed against the two-wheeler of said Vasanta Pujari. Due to the impact of accident, said Vasanta Pujari fell down and sustained grievous injuries. Immediately, he was taken to KMC Hospital, Manipal, where he was admitted as inpatient from 19/5/2018 to 20/5/2018. But unfortunately, on 25/2018, he succumbed to the injuries. The claimants are none other than the deceased parents of said Vasanta Pujari. It is their case that their son, Vasanta Pujari, was running Shabarishwara Engineering Works at Kadthala, where he was earning around 60,000 rupees per month. And he was the sole breadwinner of the family. He was aged 30 years, married or unmarried, and he was unmarried. The aged parents were solely dependent on the deceased for their maintenance and sustenance of the family. And in view of the untimely sudden death in the road traffic accident, they have lost their beloved son, who was the sole breadwinner. Thereby, they have sustained serious loss of love and affection, and also loss in income, which was solely earned by the deceased. Full stop. Hence, they filed claim petition seeking compensation for the death having occurred. Full stop. On service of notice, the owner of the offending vehicle remained absent and he was placed ex parte. The respondent number 2 insurance company filed its detailed statement of objections inter alia contending that the deceased was liable and responsible for occurrence of the accident, and the claim petition was not maintainable in view of the insurer of the vehicle in which the deceased was traveling has not been made a party to the claim petition. However, the insurance company admitted the issuance of a policy in favor of the offending vehicle, and the same was in force as on date of occurrence of accident. It also took up a plea that the driver of the offending vehicle did not possess a valid and effective driving license as on date of occurrence of accident. He has also violated the terms and conditions of the policy, and on these grounds sought for dismissal of the claim petition. Based on these pleadings, the tribunal framed relevant issues for consideration. Next para. In order to substantiate the issues and establish the case, claimant number 2, namely the mother, examined herself as PW1, got marked exhibits P1 to P19. However, respondent number 2, the insurer has not stepped into the witness box but got marked exhibit R1 as insurance policy with consent. After hearing both sides, tribunal, in considering the materials placed on record, tribunal awarded a total compensation of rupees 13,85,200 along with interest at 8% per annum. Held the joint liability against respondents 1 and 2. And in view of insurance policy being in force, directed respondent number 2 to deposit the compensation amount. With the vehement contention of learned counsel Sri Pawan Chandra Shetty on behalf of appellant claimants that the judgment and award passed by the tribunal is erroneous, as it is not considered the material evidence placed on record and is also contrary to the evidence adduced by the claimants, namely PW1, and documents placed on record. It is also contended that the tribunal is erred in awarding meager compensation by not adopting the proper methodology for assessing the income of deceased person. He further contends that tribunal is awarded meager compensation under other heads, namely loss of consortium, love and affection. Hence, on these grounds also, the compensation requires to be enhanced. Learned counsel for the appellant has also relied on a judgment of the Delhi High Court, the case of Premalata and others versus C.R. Ram and others, reported in 2022 ACJ 201, wherein the Honorable Delhi High Court has awarded compensation under the head loss of love and affection at 50,000 per claimant, and hence on this point of law decided by the Delhi High Court, he seeks interference of this court to award 50,000 under the head loss of love and affection apart from consortium as awarded by the said Delhi High Court. Full stop. On these grounds, he seeks to allow the appeal and consequently enhance the compensation. Full stop. Para. Per contra, learned counsel Sri S.V. Hegde, appearing on behalf of respondent insurer, vehemently contends that the judgment and award passed by the tribunal is in accordance to the material evidence, both oral and documentary. The same does not call for any interference. He further contends that the tribunal has awarded compensation on the ground of materials placed before the court. Admittedly, in the present case, no proof of income has been placed by the claimants to show that the deceased was earning 60,000 per month as claimed. Hence, the tribunal is awarded 9,000 as notional income, which is just and reasonable, and same does not call for interference. He further contends that the tribunal has rightly awarded 40% future prospects and deducted 50% towards personal living expenses and calculated the appropriate multiplier as laid down by the judgment of the Honorable Apex Court in the case of Sarla Verma versus Delhi Transport Corporation, and applied 17 as the multiplier, which also does not call for interference by this court. Learned counsel vehemently opposes the submissions and contentions put forth by learned counsel for the appellant with regard to enhancement of compensation on the ground of under the head loss of love and affection at the rate of 50,000 as contended or relied by the judgment of the Delhi High Court. He vehemently contends that this is opposed to the judgment of the Honorable Supreme Court, which has laid down the law, and a thumb rule has been followed since decades with regard to loss of consortium, which includes loss of love and affection, and hence he contends that 40,000 per head will be just and reasonable compensation, as the Motor Accident Act is a beneficial legislation and it cannot be inure to the benefit of though it inures to the benefit of the deceased claimant, but it should not be exorbitant and excessive. Hence, all these aspects have been considered by the judgments of the Honorable Apex Court in deciding rupees 40,000 to be the compensation under the loss of consortium per head. Accordingly, he contends that 40,000 is required to be taken as per head. Full stop. Having heard the submissions of learned counsel for the appellant claimants and learned counsel for the respondent insurer, point that arises for consideration before this court is whether the tribunal has erred in awarding meager compensation and whether the tribunal has failed to award just and reasonable compensation without appreciating the assessment of income in accordance to the material placed on record, or for that matter, the notional income chart prescribed by the Legal Services Authority. Stop. On careful perusal of material records placed before this court and on hearing the submissions of learned counsel, I am of the opinion that the tribunal has erred in awarding meager compensation, and accordingly the claimants deserve enhancement of compensation for the reasons stated herein below. Stop. It is not in dispute that on 19/5/2018 at 4:55 p.m., deceased Vasanta Pujari, while driving his Bajaj Discover vehicle two-wheeler, met with an accident due to the rash and negligent driving of a goods vehicle, which came in a high speed, resulting in the death of deceased Vasanta Pujari. Full stop. In order to establish this fact, PW1 has stepped into the witness box and produced exhibits P1 to P7. Full stop. These are the police records which are furnished by PW1 pursuant to the investigation and inquiry conducted by the jurisdictional police. Full stop. These police records have not been challenged by the driver of the offending vehicle or the respondent's hearing. Hence, under the circumstances that the said initiation of criminal proceedings by the jurisdictional police after investigation and inquiry is not challenged before the appropriate forum, and there being no contra material evidence placed before this court to disprove the genuinity and the veracity of the same, it is rightly appreciated by the tribunal and the liability is correctly fastened, and the driver of the offending vehicle to be rash and negligent, leading to the accident of deceased Vasanta Puja. Full stop. Now coming to the aspect of income, avocation and age of deceased. Admittedly, no documentary evidence has been placed by the claimants to establish or prove the fact that the deceased was running business in the name of Shabarishwara Engineering Works and earning an income of rupees 60,000 per month. In view of there being no material evidence with regard to proof of income, you have not produced anything. Proof of income, tribunal has assessed the income at 9,000 rupees as notional, assessed notional income at rupees 9,000 per month. Full stop. I am of the opinion that the income assessed by the tribunal is on the lower side. In view of the lower side, full stop. I am in agreement with the contentions raised by learned counsel for the appellant claimants that when there is no proof of income, the tribunal ought to have at least relegated itself to the notional income chart, which prescribes the notional income of rupees 12,500 for the accident year 2018. Having perused the notional income chart prescribed by the Legal Services Authority, where when there is no proof of income, for assessment of income, a standard measure has been adopted, which prescribes notional income of 12,500 for relevant year. And in the present case, accident having occurred in the year 2018, the notional income requires to be taken at 12,500 as against 9,000 adopted by the tribunal. In view of the same, 12,500 is taken as notional income. Para. The tribunal has yes. The tribunal, what are Age of the deceased as on date of occurrence of accident was 30 years, which is not disputed. Stop. The tribunal has awarded 40% as future, added 40% as future prospects in view of the fact that the deceased was aged less than 40 years and deducted 50% towards personal and living expenses, which does not call for interference by this court. As the same is in accordance to the judgment of the Honorable Apex Court in the case of National Insurance versus Pranay Sethi, reported in Sons. The tribunal has also calculated the multiplier of 17 to be taken in view of judgment of the Apex Court in Sarla Verma versus Delhi Transport Corporation, which also does not call for interference. Accordingly, if the income is taken at 12,500, well, the loss of dependency would be 12,500 plus 40%, 17,500. Into 50% to be deducted towards personal and living expenses of the deceased would be 8,750 into 12 into 17. 17 lakhs 85,000 into 12 into 70. 17 lakhs 85,000 would be the loss of dependency. Full stop. Towards loss of love and affection, tribunal is awarded 50,000 in view of the judgment of Honorable Apex Court in the case of Pranay Sethi, which has been subsequently followed in the case of Satinder Kaur. The compensation towards loss of consortium requires to be awarded at rupees 40,000 per head. In the present case, there being two dependents, namely the parents, 40,000 into 2, 80,000 requires to be awarded under the head loss of consortium, as against 50,000 awarded by the tribunal under the head loss of love and affection. I am afraid the contentions put forth by learned counsel for the appellant cannot be accepted, and it is hard to countenance for this to award a separate compensation under the head loss of love and affection as relied by him in the case of Delhi High Court judgment, for the reason that the Honorable Apex Court has already decided these matters and taken a consolidated amount of compensation to be awarded under the head loss of consortium, which also includes love and affection. Hence, the same is awarded as stated herein above at rupees 40,000 per head. Towards loss of estate and funeral expenses, tribunal is awarded 15,000 and 25,000 per head. And towards conveyance with 10,000. I do not find any reason to interfere with the same in view of there being no cross appeal or cross objections preferred by the insurance company. What, Mr. Hegde, you have not preferred anything?
For this small amount, my lord, usually will honor the judgment. Even, my lord, your lords may kindly appreciate unnecessary protraction of litigation.
All right.
Whatever, my lord, even, my lord, just compensation is to be awarded. Now, the Supreme Court made it very clear, my lord, these are all the compensation they are entitled. And head is also demarcated. And interest portion is also demarcated. That's why, my lord, this it may just compensation is to be awarded, which is the concept of section 166 of the Motor Vehicles Act. Accordingly, my lord, this is also to be reassessed. So, and 15,000 for loss of estate.
1 minute, 1 minute.
Yes.
insurance company, learned counsel for the appellant contends that this need not be interfered with. However, on appreciation of the entire materials and enhancement made by this court with regard to income of deceased and enhancement under the head loss of enhancement under the head of loss of consortium, the funeral expenses and conveyance funeral expenses awarded by the tribunal at 25,000 is modified to 15,000 as per the judgment of the Honorable Apex Court in the case of Pranay Sethi, stated supra. And so also the conveyance charges is to be set at naught in view of the same being adjusted in loss of estate and funeral expenses. Together, under the head loss of estate, funeral expense, conveyance, total amount awarded is 30,000. That is 15,000 under each head.
My lord, regarding interest, my lord, uniformly in all cases, 6% has been awarded. Even in Lok Adalat also, my lord, 6% is awarded.
Oh, now you have not filed appeal. We'll retain that 8%. For enhanced amount, we'll grant 6%.
Enhanced compensation only, my lord. I am submitting only for enhanced compensation.
Yes.
Not for the earlier amount.
In view of the discussions made here and above, I am of the opinion that the claimants are entitled to enhancement of compensation from rupees 13,85,000 to so and so, as mentioned in the table below. Accordingly, I pass the following order. Appeal is partly allowed. Judgment and award dated 28 March 2019 in MVC 1097 of 2018, passed by senior civil judge. Additional MSCT Karkala is modified. Compensation is enhanced from so and so to so and so. All of the terms and conditions stipulated tribunal stand intact. The respondent insurer shall deposit the enhanced compensation amount with interest at 6% per annum within a period of 4 weeks from the date of receipt of copy of this order. Anything else?
Yes, only that much, my lord.
Yes. Before the MSCT ಮಾಡ್ತೀರೇನಾ?
MSCT ne Swami. This is their appeal, my lord.
All right. Yes.
Obliged, my lord.
ಇದಕ್ಕೆ ತಂದಿದ್ದೀರಾ? Yes, Mr. Gangadharappa is here. Yes, sir. First of all, sorry that the judgment got delayed. No, not only for the morning, because there was, I think, gap of almost more than 5 months because of yes, because of my health conditions. I think it got further delayed. Yes. Where is he? Yes, I'm keeping good health. Yes. There is Mr. Jaykumar Patil's on record counsel. Or Bantile, no? He said he wanted to go somewhere else. Arey, or sir, online. ಏನಿಲ್ಲ. I find sufficient force in the arguments of learned counsel for appellant Shri A.V. Gangadrappa, and when a plea is made with regard to bar of jurisdiction of the tribunal, it becomes incumbent and mandatory for the tribunal to answer the said question with regard to its very jurisdiction or entertaining the list before tribunal, as it goes into the root of matter. In the present case, very jurisdiction of land tribunal to entertain or decide the application in Form 7 for grant of occupancy right is questioned. It is seen from the order of the land tribunal that there is no discussion, reasoning, or finding on the said issue of jurisdiction being vested with the land tribunal to decide application for grant of occupancy rights in the Forms of 7, considering the fact circumstance of the present case. In the instant case, the question is with regard to whether the tribunal had jurisdiction to consider the application in deciding tenancy rights of the parties. It is the case of appellant plaintiff that the same is already decided by Special Deputy Commissioner of Finance, whereas if respondent number 1, defendant number 1 vehemently contends that it is tribunal which has the jurisdiction to decide the issue, the same having been decided in his favor, civil court is barred from entertaining any proceedings further. Under the above said facts and circumstances, I am of the opinion that the trial judge has not applied his mind and has misdirected himself in only considering the aspect of bar of jurisdiction of the civil court under section 132, but has failed to appreciate the contentions raised by plaintiff with regard to other aspects enumerated in the plaint arguments, so also with regard to issue number 1 by the court itself. I am of the considered view that the trial judge ought to have considered these aspects and passed a detailed order rather than merely dismissing the suit on the ground of bar of jurisdiction under section 132(2) of the Act. Hence, it's a fit case to be remanded back to the trial court for adjudication of the matter afresh to consider and decide the issue framed by trial court in detail, notwithstanding the specific aspect of jurisdiction of tribunal in deciding the grant of occupancy rights as against the right already decided by the Special Deputy Commissioner. In view of the same, pass the following order. Appeal is allowed in part. Matter is remanded back to trial court for fresh consideration. In view of the fact that the original suit is of the year 1993, almost 2 decades having gone by, I deem it appropriate to direct the trial court to dispose of this matter within a period of 8 months Sakagata, from the date of receipt of certified copy of this judgment. Both plaintiffs as well as defendant number 1 are directed to cooperate with the trial court for disposal of the matter expeditiously. All contentions of the parties are left open. Yes, that will be better. In fact, I left that open. No, I left that open so that both of you can, otherwise it will take its own sweet path. ನೋಡಿ judgment ಓದಿ ಆಮೇಲೆ ಗೊತ್ತಾಗುತ್ತೆ. Yes, when do you want to appear? Today we are in yes. So should we make it as June 6th or June 6th? Both both the parties, namely the plaintiff as well as defendant number 1, along with their counsel, shall appear before the trial court on 6th June 2022 without waiting for further notice either from this court or the trial court. Yes, sir. Thank you for your assistance. Suma, Renuka, Ipru idralla. There's no representation on either side. Release this matter next week. ನಮ್ದು ಬೋರ್ಡ್ ಅಲ್ಲಿ ಬರ್ತಾ ಇದೆಯಮ್ಮ ಅದು ನಂಬರ್?
I appear for the respondent in this case.
I appear for appellant.
Yes, sir. Both of you are ready?
Yes, madam, I am ready. I am ready, my lord.
Yes, yes, sir.
Liability has not been disputed, my lord. Only quantum.
Claimant's appeal.
Claimant's appeal for enhancement, my lord.
Yes. Liability not disputed.
Not disputed, my lord.
Okay, what is the income?
Income has taken at 6,000 per month, my lord. Accident is of the year 2017.
Accident is of the year 2017. So to 11,000.
And
No proof of income?
no proof of income is produced. And disability, my lord.
So notional income chart to be applied.
Yes.
Yes. Age?
Age 58 years as per Aadhaar card, but 60 years has been taken. 58 years, but it has been mentioned as 60 years in the caste title. So there is no dispute with regard to the age also.
Age is 58, huh?
58 as per Aadhaar card.
Have you produced Aadhaar card?
Yes, yes, yes. It has been discussed.
Where is your Aadhaar card? Which exhibit?
60 years. Exhibit.
I do not find it in the list.
Subsequently, maybe it has been produced. It has been discussed in your last spelling page 25 bottom, my lord.
Copy of Aadhaar card available on record. Mark Agila.
Mark Agila.
So 58 is taken as the age.
Yes.
All right. What is the multiplier?
Multiplier 9 has been applied.
So that is correct.
That is correct, my lord. That is
all right. Yes, what else?
So far as disability is concerned, the doctor has assessed the permanent disability to an extent of 48.66%, my lord. Tribunal has taken 20%.
Neurobehavioral cognitive disability, you know.
Yes.
So, what was he working as?
Agriculturist, sericulturist, and dairy farming.
CT brain, right frontal sinus depressed fracture, cerebral edema. Cerebral edema, you know.
Yes, yes, ma'am. And he was tested by neuropsychologist, my lord. On the basis of testing, the disability has been assessed, my lord.
Cognitive disability 30%. He has also assessed 28% disability with neurobehavioral abnormality. So, what is this cognitive disability? 30%, 28% of neurobehavioral abnormality.
Test has been conducted by the neuropsychologist, my lord. And exhibit C4, your lord, kindly see, my lord. The doctor has given opinion, my lord, in respect of disability. Exhibit C4, your lord, kindly see, my lord.
So the tribunal says assessment made by doctor is on the higher side and comes to 20%.
Yes.
All right.
Tribunal member is not a medical expert.
All right, you can read P4.
C4, your lord, kindly see.
P4 enidu motor vehicles report.
C4, commissioner has been appointed. The doctor has been examined by appointing commissioner, my lord.
C4, you know. C4.
Clinical data sheet.
Raise C4. Keshav Prashant, you are not visible.
I'm there.
I can see Saraswati and Lakshmi behind. your image is not visible. Yes, what do you want to rely, Mr. Shantra? Exhibit C4 only?
This is clinical data sheet. You also got it, Malal.
Yes.
Neuro, behavioral and cognitive assessment. You large kind is a clinical data sheet. Ramchandraya, dated 18/6/18. Age 60 years, occupation before RTA farmer, sex male, income before RTA 10,000, marital status married, occupation after RTA nil, education SLC, income after RTA nil, language tested in Canada, and the last page of the sheet, my lord, your lord kindly see, 11, page 11.
Page 11.
Are data sheet 11 anteli last 1 to 11 and
1 ನಿಮಿಷ. Yes, 11. Yes.
ಇದರಲ್ಲಿ combined neuro behavioral and cognitive disabilities. Cognitive disability 30%, neuro behavioral disability 28%. As per DGHS telescopic sum formula, A and B 90, where 28 90, total 30 plus 28, 48.66%. Hence, the combined neuro, behavioral and cognitive disabilities 48.66%. And same has been deposited by CW1. You are also kindly see CW1, my lord. CW1 and in exhibit C1A is evidence has been recorded in handwriting and it has been typed. Exhibit C1A, your lordship kindly see.
Exhibit
C1A. C1 is the handwriting is evidence and cross-examination, my lord. C1A is typed copy, my lord. Doctor evidence. Dr. Sridhar.
Dr. Sridhar, yes. Yes.
Yes, a physician, Pulse Multi-Special Hospital, 5177, and alleged history of RTA 5/11/2017, 7 p.m. Patient sustained head injury with lacerated wound, right frontal region. On examination, patient conscious, obeying commands, moving all the limbs. CT scan brain show to right frontal sinus depressed fracture with cerebral edema. Patient underwent surgery on 7/1/17.
I think you need not read the entire thing now.
Yes,
now that
yes, that's what I'm. You will also kindly see page 3, my lord, bottom, my lord. The cross-examination, my lord.
Yes.
Question has been put regarding self-care. He need help to do some activities daily. It is not true to suggest that self-score is 0. It is false to suggest that patient is able to do his daily activities. It is false to suggest that neuropsychological disability 28% is not permanent. On the basis of NIMAN's guidelines, Dr. Pratibha has assessed the disability. Guidelines not enclosed with the report. I am not discussed with the Dr. Pratibha before assessment of disability. Dr. Pratibha is available in Bangalore. It is false to say that the disability assessed by Dr. Pratibha and myself is a year side.
Dr. Pratibha has said anything?
Yeah, Dr. Pratibha herself has been assessed the permanent disability to an extent 48.66% after examining the patient, madam, after conducting tests.
So that means that C4 is by Pratibha?
Yes.
The C4 Torsdra, that is by whom?
That is by Pratibha, my lord. That is by Pratibha.
Correct. Then who is this Shashidhar?
He has treated doctor. He is treated doctor, my lord.
Treated doctor. All right. Okay. Okay. But he has not said anything beyond what Pratibha.
Yes, ma'am. Yes, ma'am. What Pratibha has said, he has agreed with that, my lord.
Concurred.
Concurred.
Yes. Astena.
Aste, ma'am. ಆಮೇಲೆ ಲಾಸ್ ಆಫ್ ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ಲ.
Loss of amenities ಕೊಟ್ಟಿಲ್ಲ.
And future medical expenses is also not granted.
What is the future medical expenses as per the doctor?
Doctor has not stated, Mela. But because of this type of disability, Mela, since it has been stated 48.66% permanent disability, the tribunal ought to have been taken the disability at 100% functional disability, and taking the future prospects, my lord, ought to have been awarded the compensation in respect of loss of future earnings.
All right. What about pain and suffering?
Pain and suffering, 30,000 has been granted, my lord. He was inpatient for a period of 8 days.
All right.
Food and nourishment, conveyance, attendant to all 15,000 has been granted.
That is correct.
Medical expenses as per bills, 1,27,000.
All right, that is also correct.
Loss of income 6,000 prakara 2 months ಕೊಟ್ಟಿದ್ದಾರೆ 12,000.
Loss of income during period of treatment. Yesterday he was inpatient for 8 days.
8 days, man, 8 days.
So the notional income is
11,000.
Where is the discussion on that?
And this is the discussion on
2 months ಕೊಟ್ಟಿದ್ದಾರೆ.
2 months ಕೊಟ್ಟಿದ್ದಾರೆ.
So this will become 22,000. 3 months ಕೊಡಬೇಕಲ್ಲ.
Loss of amenities ಕೊಟ್ಟಿಲ್ಲ.
33,000. Loss of future earnings will change. Loss of amenities. All right. Yes. That's all.
That's all, man. That's all.
Yes, Mr. Prashant, Keshav Prashant.
As far as other things, my lord, I have no dispute. With regard to disability, my lord, but Dr. Pratibha Srinivasan was not examined. She is the neuropsychologist. She has assessed the disability. It's a matter of cross-examination of Pratibha Srinivasan. She never entered into the witness box. But the one Dr. Sridhar was given the certificate. But CW1, as per the witness examined on behalf of the claimant, CW1 is Sunil Kumar KN. It's not Sridhar. But court commissioner appointment ಮಾಡಿ Sunil Kumar KN ಅನ್ನೋರನ್ನ CW1 ಅಂತ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ.
Sunil Kumar is the commissioner. Sunil Kumar is a commissioner advocate.
Sir, ನನಗೆ ಗೊತ್ತಿಲ್ಲ. Witness list ಅಲ್ಲಿ ತೋರಿಸ್ತಾ ಇರೋದು, judgment ಅಲ್ಲಿ ತೋರಿಸ್ತಿರೋದು witness examined on behalf of the petitioner CW1 ಶ್ರೀ Sunil Kumar KN ಅಂತ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ.
Sunil Kumar KN is the commissioner advocate.
Dr. Sridhar Malad is no way concerned with this. Pratibha Srinivasan should have been examined before the through court or through commissioner or in the court. Based on the report given by Pratibha Srinivasan, one of the witness was examined and he has given the disability. So rightly, tribunal has come to the conclusion that your lordship, my kindness, as my learned, the senior counsel has read out paragraph number 20, wherein doctor said that Patient underwent surgery on 7/1/17, elevation of depressed fracture and wound improvement post-operatively. Patient was stable, recovered, and discharged. Blood, if he is suffering from severe disability as contended by the senior counsel, the date of accident is 5/1/2017. Disability assessed in a span of 1 year, 2018 the disability assessment. Unless and until the treatment is completely over, then only disability has to be assessed as per the notification issued by the central government with regard to disability assessment. Nothing was stated. In the span of 1 year, they have assessed the disability. Don't know what is the position as of now. So tribunal rightly considered the disability 20%.
On what basis?
It was a premature stage actually.
No, what is the basis? What is the basis of tribunal going against the expert opinion of the doctor?
I may read the particular paragraph.
Vodi.
At page number 17 of the judgment, my lord.
1 minute. Advocate Sunil Kumar KN. As per order sheet dated 6/6/2018, advocate by name Sunil Kumar KN is appointed as court commissioner. The tribunal ಮಾಡೋದು ಎಲ್ಲ
ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ. ನನ್ನ ಹತ್ರ depositions ಇರಲಿಲ್ಲ, so that's
how would you know? Because you have not conducted the trial. Yes, sir. You want to?
And he was not cross-examined, my lord. They said there is no cross-examination.
All right. Which page you want to read, Mr. Keshav Prasad?
Page number 17.
Ink page 24, my lord. Ink page 24.
All right. Yes, sir.
Visiting to the hospital on 9/6/2018, he complains headache, memory disturbance, and irritable forgetfulness, and also complained right eye vision and pain over shoulder, neck, both leg pain present, and has required assistance for his day-to-day activities. Hence, patient was referred to neuropsychological evaluation. On neuropsychological assessment, patient has significant deficits in mental speed, focused attention, verbal and category fluency, and other frontal lobe, temporal lobe involvement, which was assessed cognitive disability 30%. He has assessed 28% disability with neurobehavioral abnormality. 28% neurobehavioral abnormality. The patient personally come to the witness box. He has answered all the questions posed to the in the cross-examination. That itself indicates he is perfectly all right. Absolutely, there is no issues on that. Hence, the petition sustained combined neurobehavioral cognitive disabilities at 48.66%. During the cross-examination, he deposed that he is working as a consultant doctor at Pulse Hospital and has conducted surgery and opined that a patient sustained right frontal depressed fracture, cerebral edema. He denied that a patient is able to do his daily activities and said neuropsychological disability is not permanent. He denied the assessment of disability at higher side. Therefore, the tribunal proceed to examine the records available on hand after scrutiny of oral and documentary evidence in the light of the nature of injuries, line of treatment, and his present condition assessed during his examination before this tribunal. But this is what the observation. Just I wanted to take your lordship's attention on this. But tribunal has observed. Tribunal has seen the witness. He has answered up to all the questions posed by the insurance company advocate. There was no issues. But seeing all these records and nature of line of treatment, nature of injuries, and present condition during the trial, tribunal has come to the conclusion the assessment of the doctor is on higher side. Hence, if the disability is taken 20% to the whole body, it would be both justified. But 48% disability, neurobehavioral and neurocognitive disability, definitely it's not possible to answer any questions. But fracture, suffering the fracture of upper limb or lower limb is something different. 48% disability, 46% disability, cognitive disability with regard to the head injury, definitely nobody can answer the questions. Or ಎಲ್ಲ ಜ್ಞಾಪಕ ಶಕ್ತಿನೂ ಇದೆ, ಎಲ್ಲದಕ್ಕೂ ಆನ್ಸರ್ ಮಾಡ್ತಾರೆ. He has personally come to the witness box. He has laid his evidence.
So where is the cross-examination of PW1? Let us see that.
I don't have my deposition. But this is what the observation of the tribunal.
No. Let us see on what basis the tribunal
please.
That is questioned here. What is the basis of tribunal assessment? Where is PW1's cross-examination? You don't have evidence of PW1?
No, my lord, I don't have.
ಮತ್ತೆ ನೀವೇನ್ ರೆಡಿ ಅಂತ ಏನ್ ಹೇಳಿದ್ರಿ ಮತ್ತೆ?
No, my lord, I thought that, my lord, I have already taken 2 adjournments in this case. So today I don't want to, my lord, drag on this issue.
Oh,
The day before yesterday, my lord, this matter was listed.
If you are trying to rely on the finding of the tribunal that the tribunal is assessing its examination condition being assessed as examination before this tribunal.
But I have, my lord, I got the, my lord, the uploaded evidence in the website, my lord. May I read?
Yes.
ಪಾಟಿ ಸವಾಲು ಎರಡನೇ ಎದುರ ಪರ SR ವಕೀಲರಿಂದ ಅರ್ಜಿದಾರರಾದ ರಾಮಚಂದ್ರಯ್ಯ ನನಗೆ ಹೆಣ್ಣು ಕೊಟ್ಟ ಮಾವನಾಗಿದ್ದಾರೆ.
What dated?
This is RW. No, my lord. This is RW1 is uploaded. It's not
PW1.
It's not, my lord, PW1 upload ಆಗಿಲ್ಲ.
Dated 3/2/2018, my lord.
2018.
Yes. ಪಾಟಿ ಸವಾಲು ಎರಡನೇದಾರರ ಪರ LSR ವಕೀಲರಿಂದ ನಾನು ಮುಖ್ಯ ವಿಚಾರ I will read, my lord. ನಾನು ಮುಖ್ಯ ವಿಚಾರಣಾ ಪ್ರಮಾಣ ಪತ್ರದ ವಿಚಾರಗಳನ್ನು ನಾನೇ ನನ್ನ ವಕೀಲ ಹೇಳಿ ಬರೆಸಿ ಹಾಕಿಸಿದ್ದೇನೆ. ಅಪಘಾತ ಆದಾಗ ಸಂಜೆ ಸುಮಾರು 7:30 ಆಗಿತ್ತು. ನಾನು ಆ ಸಮಯದಲ್ಲಿ ಮೋಟಾರ್ ಸೈಕಲ್ ನಲ್ಲಿ ಅರುಣಾ ಅವರೊಂದಿಗೆ ಹೋಗುತ್ತಿದ್ದೆ. ಅರುಣಾರವರು ನನಗೆ 3-4 ವರ್ಷಗಳಿಂದ ಪರಿಚಯ. ಅವರು ರಾಮನಗರದವರು. ಆ ದಿನ ನಾನು ರಾಮನಗರದಲ್ಲಿ ಇರುವ ನನ್ನ ಮಗಳ ಮನೆಗೆ ಹೋಗಿದ್ದೆ. ನಮ್ಮ ಊರಿಗೆ ವಾಪಸ್ ಹೋಗಲು ತಡವಾಗಿದೆ ಎಂದು ನನ್ನ ಅಳಿಯ ನರಸಿಂಹಮೂರ್ತಿರವರು ಅರುಣಾರವರೊಂದಿಗೆ ಮೋಟಾರ್ ಸೈಕಲ್ ನಲ್ಲಿ ಕಳಿಸಿಕೊಟ್ಟಿದ್ದರು. ನರಸಿಂಹಮೂರ್ತಿ ಎಂದರೆ 1ನೇ ಎದುರುದಾರ ಎಂದರೆ ಸರಿ. 1ನೇ ಎದುರುದಾರ ನನ್ನ ಅಳಿಯ ಎಂದರೆ ಸರಿ. ನನ್ನನ್ನು ಆ ದಿನ ಕಳಿಸಿಕೊಟ್ಟ ಮೋಟಾರ್ ಸೈಕಲ್ ನನ್ನ ಅಳಿಯನದ್ದೇ ಆಗಿದೆ. ನನ್ನ ಅಳಿಯ ವಕೀಲರಾಗಿದ್ದಾರೆ. ಅವರು ರಾಮನಗರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡುತ್ತಾರೆ. ನಾನು ಮೋಟಾರ್ ಸೈಕಲ್ ನಿಂದ ಬಿದ್ದೆ ಎಂದು ಹೇಳಿದ್ದು. ಬಿದ್ದ ಮೇಲೆ ನನಗೆ ಪ್ರಜ್ಞೆ ಇರಲಿಲ್ಲ. ಅಪಘಾತವಾದಾಗ ನನ್ನ ಅಳಿಯ ರಾಮನಗರದಲ್ಲೇ ಇದ್ದರು. ಅಪಘಾತವಾದ ನಂತರ ಅರುಣಾರವರು ನನ್ನನ್ನು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಲಿಲ್ಲ. ನನ್ನ ಅಣ್ಣ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದರು. ನನ್ನನ್ನು BGS ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿಸಿ ನನ್ನ ಅಳಿಯನನ್ನು ಫೋನ್ ಮಾಡಿ ಕರೆಸಿದರು. ನನ್ನನ್ನು BGS ಆಸ್ಪತ್ರೆಗೆ ನನ್ನ ಅಳಿಯನೇ ಸೇರಿಸಿದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅಪಘಾತ ಸ್ಥಳಕ್ಕೂ ನಮ್ಮ ಗ್ರಾಮಕ್ಕೂ 1/2 ಕಿಲೋಮೀಟರ್ ಅಂತರವಿದೆ. ನನ್ನನ್ನು BGS ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿಸಿದಾಗ ನನಗೆ ಅಪಘಾತ ಮಾಡಿದ ಮೋಟಾರ್ ಸೈಕಲ್ ನನ್ನ ಅಳಿಯನಂತೆ ಎಂದು ಗೊತ್ತಿದ್ದರು. ನಾನು ಆ ಸಂಖ್ಯೆಯನ್ನು ಆಸ್ಪತ್ರೆ ಹೇಳಿ ಬರೆಸಿಲ್ಲ ಎಂದರೆ ಅದರ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆಮೇಲೆ ಹೇಳಿದ ಮೋಟಾರ್ ಸೈಕಲ್ ನಲ್ಲಿ ಹೋಗುವಾಗ ನನಗೆ ಅಪಘಾತ ಆಗಿದ್ದೆ. ಆದಲ್ಲಿ ಸದರಿ ಮೋಟಾರ್ ಸೈಕಲ್ ಸಂಖ್ಯೆ ನನ್ನ ಅಳಿಯ ಅಥವಾ ನನ್ನ ಅಣ್ಣ ಆಸ್ಪತ್ರೆ ಹೇಳಿ ಬರೆಸಬಹುದು ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನನಗೆ ಜ್ಞಾನ ಇರಲಿಲ್ಲ. ನನಗೆ 5 ದಿನಗಳ ನಂತರ ಜ್ಞಾನ ಬಂತು. ಪೊಲೀಸರು ನನ್ನಿಂದ ಹೇಳಿಕೆ ತೆಗೆದುಕೊಂಡಿಲ್ಲ. ನನ್ನ ಅಣ್ಣನ ಹೇಳಿಕೆ ತೆಗೆದುಕೊಂಡಿದ್ದರು. ನನಗೆ 2 ಹೆಣ್ಣು ಮಕ್ಕಳು, 1 ಗಂಡು ಮಗ. ಅಪಘಾತದ ಬಗ್ಗೆ ನಮ್ಮ ಕುಟುಂಬದವರು ಯಾರಾದರೂ ತಕ್ಷಣ ದೂರು ಕೊಡಲು ತೊಂದರೆ ಇರಲಿಲ್ಲ. ಎಂದರೆ ನನ್ನ ಸ್ಥಿತಿ ಗಂಭೀರವಾಗಿದ್ದ ಕಾರಣ ಅವರೆಲ್ಲ ಗಾಬರಿಯಲ್ಲಿ ಇದ್ದರು ಎನ್ನುತ್ತಾರೆ. ನಮ್ಮ ಊರಿನ ಪೊಲೀಸ್ ಠಾಣೆ ಸುಮಾರು 20 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿದೆ. ನಮ್ಮ ಊರಿನಿಂದ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಸುಮಾರು 45 ನಿಮಿಷದಲ್ಲಿ ಬರಬಹುದು ಎಂದರೆ ಸರಿ. ಈ ಅಪಘಾತದ ಬಗ್ಗೆ ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಯಾವುದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಾಕ್ಷಿ ನುಡಿದಿಲ್ಲ. ಅಪಘಾತದ ನಂತರ ಅರುಣಾರವರು ಪುನಃ ನನಗೆ ಸಿಕ್ಕಿಲ್ಲ. ನಾನು ತಿಳಿಸಿರುವಂತೆ ಅಪಘಾತಿನ ನಾನು ಅರುಣಾವರೊಂದಿಗೆ ಮೋಟಾರ್ ಸೈಕಲ್ ಹೋಗುತ್ತಿರಲಿಲ್ಲ. ಅದರ ಪರಿಣಾಮ ನಾನು ಮತ್ತು ನನ್ನ ಅಳಿಯ ಶಾಮೀಲಾಗಿ ಸುಳ್ಳು ದೂರು ನೀಡಿದ್ದೇವೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. BGS ನಾನು ಒಳರೋಗಿಯಾಗಿ ಚಿಕಿತ್ಸೆ ಪಡೆದುಕೊಂಡನೆ ಎಂದು ನನಗೆ ಜ್ಞಾನ ಇರಲಿಲ್ಲ. ಆದ್ದರಿಂದ ಏನು ಚಿಕಿತ್ಸೆ ಪಡೆದುಕೊಂಡೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆ ನಂತರ ನನ್ನನ್ನು ಪಲ್ಸ್ ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿಸಲಾಯಿತು ಎಂದು ನನಗೆ ಜ್ಞಾನ ಬಂದ ನಂತರ ತಿಳಿಸಿದರು. 12/1/17 ಆಸ್ಪತ್ರೆ ಬಿಡುಗಡೆಗೊಂಡ ನಂತರ ಯಾವುದೇ ತೆಗೆದುಕೊಂಡಿಕೊಂಡೆ ಎಂದರೆ ನಾನು 15 ದಿನಕ್ಕೊಮ್ಮೆ ಚಿಕಿತ್ಸೆಗೆ ಹೋಗುತ್ತಿದ್ದೆ ಎನ್ನುತ್ತಾರೆ. ನಾನು ಯಾವುದೇ ಫಾಲೋ ಅಪ್ ಚಿಕಿತ್ಸೆ ಪಡೆದುಕೊಂಡಿಲ್ಲ. ನಾನು ಮೆಡಿಕಲ್ ಬಿಲ್ಗಳನ್ನು ಸೃಷ್ಟಿ ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಹಾಜರುಪಡಿಸಿರುವ ಫಾರ್ಮಸಿ ಬಿಲ್ಲುಗಳಲ್ಲಿ ಯಾವುದೇ ಸೀಲ್ ಅಥವಾ ಸಹಿ ಇರುವುದಿಲ್ಲ ಎಂದರೆ ಕಂಪ್ಯೂಟರ್ ಬಿಲ್ಲು ನೀಡಿದ್ದಾರೆ ಎಂದು ನನಗೆ ಹೇಳಿದ್ದಾರೆ. ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣಾ ಪ್ರಮಾಣ ಪತ್ರದ 3ನೇ ಪ್ಯಾರ ತಿಳಿಸುವಂತೆ ಖರ್ಚು ಆಗಿಲ್ಲ, ಸುಳ್ಳು ಹೇಳಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ತಿಳಿಸಿರುವಂತೆ ನನಗೆ ಯಾವುದೇ ತೊಂದರೆ ಅಥವಾ ನ್ಯೂನತೆ ಉಂಟಾಗಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಆ ಸಮಯದಲ್ಲಿ ವ್ಯವಸಾಯ ಇತ್ಯಾದಿ ಮಾಡುತ್ತಾ ತಿಂಗಳಿಗೆ 15,000 ರೂಗಳು ಸಂಪಾದಿಸಿದೆ ಎಂಬ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನಾನು ಯಾವುದೇ ಸಂಪಾದನೆ ಮಾಡುತ್ತಿರಲಿಲ್ಲ, ಆದ್ದರಿಂದಲೇ ಯಾವುದೇ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿದರೆ ಸರಿಯಲ್ಲ. ನನಗೆ ಇನ್ನೂ ಕೂಡ ಶಸ್ತ್ರಚಿಕಿತ್ಸೆ ಮಾಡಬೇಕಾಗಿದ್ದು, ಅದಕ್ಕೆ 3 ರಿಂದ 4 ಲಕ್ಷ ಖರ್ಚು ಬರುವುದು ಹೇಳಿದ್ದು, ಆ ಬಗ್ಗೆ ದಾಖಲೆ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ನನ್ನ ವಯಸ್ಸು 70 ವರ್ಷ ಹೆಚ್ಚಾಗಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಅಪಘಾತ ಕಾರಣ ಯಾವುದೇ ನ್ಯೂನತೆ ಅಥವಾ ಆರ್ಥಿಕ ನಷ್ಟ ಉಂಟಾಗಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. That's all, my lord.
But this is my lord, the lengthy cross-examination done. He has given all the answers, my lord. He know each and every aspect. There is no abnormal, my lord, as said by the doctor, my lord. He has assessed 28% disability with neurobehavioral abnormality. But if a person suffering from 28% with neurobehavioral abnormality, is possible to answer these questions to this extent? Or ಎಲ್ಲಾದರೂ ಜ್ಞಾಪಕ ಇದೆ, ಪ್ರತಿಯೊಂದು ಹೇಳ್ತಾರೆ, ಎಲ್ಲದನ್ನು ಹೇಳ್ತಾರೆ. That's my humble submission is that, my lord, such being the fact, the assessment done by the tribunal is just and proper. There is no question of increasing the disability aspect. As far as income is concerned, I have no issues. As per the chart, 11,000 should have been considered. Tribunal has taken 6,000 rupees. That is required to be enhanced. 46% to 48%, 48.66% disability, neurobehavioral and neuropsychological disability. Is it possible to do all these things? That itself indication, right? It is an exaggerated version by the doctor. And that particular Dr. Millard who was assessed the disability, Dr. Pratibha Srinivasan, was not at all examined. She should have entered into the witness box. It's a matter of cross-examination. No? Based on the report given by Pratibha Srinivasan, some other doctor has given the evidence.
Oh, he is the treated doctor. He is examined and he was cross-examined by the.
Our cross-examination Bengaluru, she is very much available in Bangalore. That being the case, she should have been examined. Commissioner appointment examine. That was not done.
All right, but this Dr. PW1 is a treated doctor.
Yes, he is a treated doctor. Yes, categorically stated in para 2, page 3, my lord.
Treated doctor. I'm not saying that Millard is not a treated doctor, but disability assessment, this neurological, psychological disability was assessed by another doctor. He may
What happened, Mr. Keshav Prasad? Volume is gone. Keshav Prasad.
I'm sorry, my lord, due to some technical issues,
All right.
got disconnected.
Why to disbelieve this report furnished by Dr. Pratibha?
My lord, I am not disputing it.
Yes.
My lord, she should have been, my lord, it's a matter of cross-examination. My lord, I want to elicit some other things. She has, my lord, assessed the disability. She should have been examined. But commissioner appointment ಮಾಡಿ ಬೇರೆ ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋ ಬದಲು ಇವ್ರನ್ನೇ ಮಾಡಿಸ್ಬೋದಿತ್ತಲ್ಲ. Because my lord, she is, my lord, neurosurgeon. ಅವರೇ ಹೇಳ್ತಾರೆ, the person who has given the evidence, my lord, he himself said that this was assessed by Dr. Pratibha Srinivas. And she was very much in Bangalore. She could have been examined. ಇವ್ರನ್ನ ಮಾಡುವಂತ ನೆಸಿಟಿ ಇಲ್ಲ. ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡೋದಾದ್ರೆ. But if there are many doctors who are very much busy in their day-to-day this thing, they may not be able to come to the court. That's why my court commissioner was appointed. They could have examined this person.
All right. Then what stopped you from not calling her and filing an application?
But it is for the claimant, Malad. He has to prove. He has to prove his disability. He has to prove his line of treatment.
All right. All right. But the treated doctor has also assessed on the clinical analysis. He has also come to the same conclusion.
That's what I said, Malad.
He has filed his affidavit. You have cross-examined him. Even if Pratibha has not come before the court, this person, he has also assessed. In his evidence, he says, I was a doctor, neurosurgeon from past 10 years.
That's what
Pulse multi-speciality hospital on such and such a date. And according to him, the assessment he has given.
The assessment was done by Pratibha Srinivas, not by this person. Lord, on examination, page number 17. On examination, Lord, on neuropsychological assessment has significant deficits in mental speed, focus, attention, verbal and category fluency, and other behavioral issues. This is what the observation. If that is the case, my lord, then definitely, my lord, the claimant would have not answered any of the, my lord, questions.
So that we do not know. That we do not want to step into the forte of the expert doctors. They have to say. Are you agreeing to any amount of disability lesser than 48%? Over and about 20% by the tribunal? No, I am not forcing you. It is up to you.
No, it's not that, my lord. Shantraj or always I had a fight with Shantraj sir with regard to this disability assessment.
What, Mr. Shantraj, you are sticking on to 48.66 or is there anything that you want to propose?
I can't reduce the disability, my lord.
No, reduce Allah. This court will pass an order, judicial order.
Yes, my
No doubt.
lord. Certainly, my lord. Certainly.
Court will pass. I am just understanding from both of you.
The 48.66% disability ಏನಿದೆ 50% ಮಲಾಡ್ may be taken. 20% ತಗೊಂಡಿದ್ದಾರೆ. 50% of
how can that be reduced to 20%?
No, that's what I'm not saying about 50% of the total
How?
disability.
On what basis that 50% is taken? It's a neuro behavioral cognitive disability. Even if his body physical appearance and physical disability is not there, neuro disability pulls down a man, sir, or a person. There may not be physical disability, but neuro disability and cognitive disability is a disability which is worse than physical disability, because your mind has to work. Unless your mind works, your body will not move. And he has suffered a head injury. There is an edema.
That's the, that unless my mind is not working, definitely I may not be able to move. That's what my submission is. But if he is able to answer all my questions and your lordship has seen, like Shantara has read 2-3 pages of cross-examination, that itself indicates, that there is no issues with regard to his the memory loss or any other disability with regard to the mental this thing.
Therefore, there is no 100% disability. It has been 48.66% only. If he has not answered,
50% is okay.
Yes, man.
52% is okay. Yen Madana, you want to say something or should I proceed?
Your lordship can proceed, my lord. Yes, your lordship can proceed.
Yes, Shant, Keshav Prasant, anything? I don't think we'll be able to complete. Take it up. We'll take it up at 2:30. How many
Yes,
more?
sir.
50? 250. All right. Yarrow. All right. We'll dictate this in the afternoon.
Yes.
Please.
In the afternoon, we'll take it up.
Yes,
even
yes.
if I start now, it's 1:15.
Yes, yes.
Complete by 1:30.
Yes.
It other matters, if they are not here, then we can adjourn it. Do it, huh? 52, serial number 52, 53. 52. Girish Baladare and Pradeep B. Vijay Kumar. All right, we'll call it in the afternoon. Huh? Yaudu? 41. Before this court. Padi. Tribunal and no? Sorry, tribunal. Serial number 41 before this court.
I make one submission, Malad.
Yes, Prashant.
I have one more matter, division match, Malad. I will finish it off and join.
Yes, you can.
Please.
ಮಧ್ಯಾಹ್ನ
What
Hello? Court officer? Court officer? Court officer?
ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್?
ಮೇಡಮ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 53 ಏನಾಯ್ತು?
ಸರ್ ಮಧ್ಯಾಹ್ನ ಇದೆ ಸರ್, ಕರ್ದಿವಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 50
ಮಧ್ಯಾಹ್ನ ಇದೆ ಸರ್.
ಯಾರು ಇಲ್ವಾ?
ಯಾರು ಇಲ್ಲ ಸರ್.
ಹೇಳಿ.
ಮಧ್ಯಾಹ್ನ 2:30 ಇದೆ ಸರ್.
ಮಧ್ಯಾಹ್ನ ಸಿಟಿಂಗ್ ಇದೆಯಾ?
ಹೌದು ಸರ್.
ಓಕೆ ಸರಿ, ಥ್ಯಾಂಕ್ ಯು.
ಓಕೆ ಸರ್.
ಓಕೆ ಸುರೇಶ್, ಅದೇ ಬರ್ತಾ ಇದೆ. ಅದು ಮೊದಲು ಇನ್ನೊಂದೇನೋ ಡಿಸ್ಪ್ಲೇ ಆಗ್ತಾ ಇತ್ತು.
Brother audible, sir? Kelsa idೆಯಾ sir? Hello? Kelsa idೆಯಾ sir?
Yes, Allikarjun. No? 52. 52 ರೀ 53 ಯಾರು 52 ಅದು 52.1 ಮತ್ತೆ 53 ಅಂತೀರಾ ವಾಟ್ ಇಸ್ ಟು ಬಿ ಡನ್
ಕಂಪನಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಆಕ್ಪಲ್ಸಿಯಲ್ಲಿ ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅವರು ರಿಲೀಸ್ ಮಾಡಿದ್ರೆ ಅವರು ಏನೋ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಐತೆ.
Well, what is to be done? It should be taken as heard or whether we have to hear him. He's claimant. New insurer. Put it. ಅವರು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ
ನಾವೇ ತಗೊಂಡಿದ್ದೀವಿ.
So what is this act policy is only what is this act policy? So the rider the rider can claim against third party, not against. The pillion rider has filed.
You want to say except premium.
Patilla. All right, let him come. Let us see what he has to say. Learned counsel for appellant Mallikarjun on behalf of B. Pradeep files a memo with citation in the case of Oriental Insurance Company versus Ganesh Devadiga and others. It was taken on record. No representation on behalf of respondent number 1. Hence, relist this matter next week or week after that. Next week. This one meme kodi. Green sheet kodi. ಹೌದು ರೀ ಸರ್. ಬರಲ್ವಾ? ಡಿ ವಿಜಯ್ ಕುಮಾರ್. All right, let us see. He may come. Any further submission, Shantaraj?
No further submission, my lord.
Yes, Euro, Amma Keshav Prasad. Nothing. This appeal is preferred by the claimant. Facts alone. Is the vehement contention of learned counsel appearing for the claimant that the judgment and award passed by the tribunal is erroneous, as it has not considered the relevant materials, both oral and documentary, placed before the tribunal. Stop the contents. The further contents that the tribunal is assessed a meager amount as income of the appellant, of the claimant, without taking into consideration the notional income chart. Full stop. Next paragraph. The further contents that the tribunal has grossly erred in not taking into consideration the evidence of CW2, evidence of CW1, namely Sridhar Allah,
Sridhar.
who's the doctor who treated the claimant.
He has been treated as CW1A, my lord.
CW1A na?
ಆ ಒನ್ ಕಮಿಷನರ್ ಒನ್ ಅಂತ ಮಾಡವ್ರೆ, ಅಡ್ವೊಕೇಟ್ ಕಮಿಷನರ್ ಇವರು.
There is no one. How can the advocate become the witness? Oh no.
ಆ CW1 ಕರೆಕ್ಟ್ ಇದರಲ್ಲಿ ಇದಕ್ಕೆ ಹ್ಯಾಂಡ್ ರಿಟನ್ ಇದರಲ್ಲಿ CW1 ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಕರೆಕ್ಟ್ CW1.
Is CW1 only, sir. Dr. Sridhar is CW1.
Yes, ma'am. Typed portion
C1A. Other C1A. But the handwriting version is C1.
C1, yes.
CW1 ಬರಬೇಕಾಗಿತ್ತು, C1 ಅಂತ. C1. treated the claimant and who was very categorically deposed before the court on proper clinical and neuropsychological evaluation and analysis. That the claimant is assessed to have cognitive disability at 30%, neurobehavioral abnormality at 28%, and together combined neurobehavioral and cognitive disability at 48.66%. This witness, namely Dr. CW1, was subjected to cross-examination, and nothing much has been elicited in the cross-examination of the medical expert CW1. But however, the tribunal, on an erroneous application of mind, has assessed the disability to an extent of 20%, which is illegal and contrary to the medical evidence expressed and opined by the doctor on the basis of clinical and neuropsychological neurobehavioral assessment. It is further contended that CW1 has based its analysis also on the basis of the medical report furnished by Dr. Pratibha Sharan, who was given, what is that exhibit? C4.
C4, my lord.
Which is produced at exhibit C4, which is a neurobehavioral and cognitive assessment clinical data sheet. He has based his reliance even on the report submitted by the said specialist Dr. Pratibha Sharan, who is a neuropsychological counseling expert and neuropsychology having done at NIMHANS and qualified in FNR, that is Fellowship in Neuro Rehabilitation, Consultant, Neuro Rehabilitation, full stop, as per exhibit C4. Hence, the assessment of disability made by the tribunal is totally contrary to the medical expert's opinion, and therefore the same requires to be set aside. Full stop. Learned Counsel further contends that the compensation awarded under other heads, namely pain and suffering, loss of income during treatment period, is on the lower side and the same requires enhancement. Full stop. He further contends that the tribunal has erred in not awarding any amount of compensation towards loss of amenities. Full stop. Learned Counsel further contends that the compensation awarded under other heads are also on the lower side and hence the same requires suitable enhancement commensurate to the injuries suffered by the claimant due to the accident. Full stop. On these submissions, Third Counsel for the appellant seeks to allow the appeal, consequently enhance compensation, which would be just and reasonable. The facts and circumstances of the case on hand. Full stop. Per contra, learned counsel Shri Keshav Prasant, appearing on behalf of the respondent insurer, respondent number 2 insurer, vehemently contends that the judgment and award of compensation, judgment and award passed by the tribunal is in accordance to the material evidence placed before the court, both oral and documentary. Come on. And in view of the fact that there is no material proof of income and avocation of the claimant, the tribunal has rightly taken notional income at rupees 6,000 per month. And there is no illegality or perversity in the order passed by the tribunal. He further contends that with regard to the disability assessed by CW1, namely doctor, which is seriously disputed, the tribunal has rightly assessed the disability to an extent of 20% to the whole body after properly analyzing the demeanor of the witness and the assessment made by the court on the questions that were being answered by the witness while he was being cross-examined by the counsel for insurance company. As the witness has answered all the questions without any difficulty, the tribunal has properly assessed the disability to an extent of 20%. Which does not warrant interference at the hands of this court. He further contends that under all other heads, tribunal is awarded just and reasonable compensation, which also does not call for interference by this court. On the basis of these submissions, the Third Counsel seeks to dismiss the appeal and affirm the judgment award passed by the tribunal. Having heard the submissions of learned counsel for appellant claimant and learned counsel for respondent number 2 insurer, point that arises for consideration before this court is whether tribunal has erred in awarding eager compensation calling for interference of this court, whether the tribunal has erred in taking disability to an extent of 20%, contrary to the opinion expressed by the doctor to an extent of 48.66%. Whether enhancement is called for, present case on hand. It is not in dispute. The accident having occurred on 5/1/2017 is not in dispute. The liability fastened on the insurer is also not in dispute. The injuries sustained by the claimant due to the occurrence of accident is also not in dispute. However, the quantum of compensation awarded by the tribunal is questioned by the claimant, to stop. The respondent number 2 insurer has seriously disputed the disability to be awarded at 48.66% as assessed by the doctor, namely CW1, which is seriously canvassed by learned counsel for the appellant claim. Learned counsel, Learned counsel for the claimant has seriously contended that the tribunal has erred in not assessing the proper income of claimant, despite the fact that claimant has stated on oath, claimant has stated on oath that he was an agriculturist and doing dairy farming and earning rupees 15,000 per month. Full stop. However, admittedly, no material documents has been placed before the court to prove the income or avocation of the claimant. In the absence of such proof of income, tribunal has assessed the income to be at rupees 6,000 per month. Full stop. I am in agreement with the learned counsel for the appellant claimant that the said income assessed by tribunal is on the lower side, as even when there is no proof of income, the tribunal and this court will have to do guesswork for making an assessment of income. And in the present case on hand, the accident having occurred in the year 2017, to make a proper assessment, the Legal Services Authority has prescribed a standard notional income chart, according to which for the year 2017, the notional income is prescribed at 11,000 per month. The tribunal ought to have relied on the notional income chart for assessment of income of the claimant when there is no proof of income. Accordingly, I deem it appropriate to assess the income of claimant at rupees 11,000 as against rupees 6,000 taken by the tribunal. It is a vehement contention of learned counsel for appellant that he has examined the doctor as CW1 through the court commissioner. The same is produced and marked as Exhibit C1 and C1A, wherein the doctor who has treated the patient has clearly stated on oath that the claimant has undergone right frontal sinus depressed fracture with cerebral edema, OEDEMA, and has undergone surgery. And on 7/1/2017, he had a depressed fracture, cranioplasty, and wound debridement post-operatively. And thereafter, pursuant to discharge, he was taking outpatient treatment. In view of the post-operative complications developed by the claimant, he was referred to neuropsychological evaluation. On the basis of neuropsychological assessment, significant deficit in mental speed, focused attention, verbal and category fluency, and other frontal lobe, temporal lobe involvement was noticed, due to which the claimant came to be assessed for cognitive disability to an extent of 30%. He was also assessed with a disability of 28% with neurobehavioral abnormality. Hence, the total disability came to be assessed at 48.66% by the Dr. CW1 who treated the claimant. Full stop. CW1 who treated the claimant is a consultant doctor at Pulse Hospital, having put in experience of more than 10 years in this field of neuropsychology. In view of the medical opinion expressed by the treated doctor CW1, based on his own analysis and evaluation of the claimant, and also on the reliance placed by him of the assessment and evaluation made by the neuropsychologist Dr. Pratibha from NIMHANS, who was also assessed the disability to be at 48.66%. It is contended that the disability ought to have been taken by the tribunal to an extent of 48.66% to the whole body, rather than 20% adopted by the tribunal. Full stop. In a case of medical deformity or disability, expera, where there is serious medical complications to the patient, namely the claimant herein, the assessment has to be made by the expert, namely expert doctor, rather than by the court, as the courts are not experts in the field of medicine. In the present case on hand, the neuropsychologist and the assessment made by physician CW1, neurosurgeon who was practiced for more than 10 years and having deposed before the court with regard to the disability based on assessment and evaluation of claimant based on medical records. It is not right or proper for the court to step into the armchair of the expert to express its opinion on disability, medical disability, for which the court is not capable or proficient. Therefore, the assessment made by the tribunal with regard to 20% disability is not justifiable and the same is not acceptable. Full stop. In view of there being no contra material evidence placed or elicited in the cross-examination by respondent number 2 insurer from the mouth of the from the witness, namely CW1, the same will have to be accepted on its evidentiary value. Full stop. Therefore, the assessment will have to be made on the medical expert's opinion of disability rather than the court's general assessment of whole body disability, which is divided into 1/3, which will not be appropriate in the present case on hand, as it's not a physical disability, it is a mental neuropsychological disability. on cognitive disability and cognitive disability. Full stop. Hence, on the above discussions, basis of above discussions, the loss of future earnings due to the disability suffered by the claimant in the accident would be 12,000, 11,000.
11,000 into 48.66%, my lord. It will come to 5,352.
11,000 into 12 into 48.
48.66% into 9, my lord. Multiplier 9.
11,000 into 12 into 9 into 48.66 by 100.
5,352 it will come, my lord. And total amount 5,78,080 it will come, my lord.
Esto 5,78,000.
78,080, my lord.
5,78,800.
80, my lord. 78,080.
78,080, no?
80.
All right, 5,78,080. As against 1,29,600 awarded by the tribunal. Either one more para you'll have to add before this. Multiplier. So in view of claimant's age being 58 years, the appropriate multiplier would be 9. As held by the Honorable Apex Court in Sarla Verma versus Delhi Transport Court. Para. Under the head, pain and suffering, tribunal is awarded 30,000, which I find is on the lower side in view of serious disability suffered by the claimant and having been inpatient. Either inpatient?
8 days.
Having been inpatient in the hospital for 8 days and thereafter having taken post-operative treatment with the doctor and having suffered mental cognitive disability and neuropsychological disability, I find 50,000 would be a reasonable amount to be granted under this head, as against 30,000. Full stop. Towards food, nourishment, conveyance charges, and attendance charges, the tribunal is awarded 15,000. As the claimant was admitted for 8 days, I do not find any legal infirmity in the said compensation awarded. Under the head medical expenses, the tribunal is awarded 1,27,036, which is on the basis of medical bills produced by the claimant. Exhibits. What are your medical bills exhibits?
Exhibit P6, my lord.
Exhibit P6 and P7.
7.
Which also does not call for interference by this court. Full stop. Para. Towards loss of income during the period of treatment, tribunal is awarded 12,000. In view of the fact that this court has enhanced the income of claimant to at 11,000 rupees, taking the two months as treatment period. 11,000 into 2 would be 22,000, as against 12,000 awarded by.
At least 4 months it may be awarded.
Yes, sir, you are going to get 48% disability.
ನನಗೆ ಪಾರ್ಟಿ ಸಫರ್ ಆಗಿದ್ದಾರೆ ಅವರು
No, see, now what happens is that if he was hale and healthy, then that disability period would have been counted because he could not go back and work.
He can't work well.
So that is why that once the disability is given, there is no point in giving this again. If he was inpatient for 30 days, then it makes sense. You're inpatient only for 8 days.
ಅಲ್ಲ ಆ ಬೇಸಿಸ್ ಮೇಲೆ ಕಾಂಪನ್ಸೇಷನ್ ಇದು ಮಾಡಕ್ ಬರಲ್ಲ, ಡಿಟರ್ಮಿನ್ ಮಾಡಕ್ ಬರಲ್ಲ ಕಮ್ಮಿ ಡೇಸ್ ಇದಾನೆ ಅಂತ. ಅಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ 3 months could have been.
All right, make it 11,000 into 3 months, 33,000. Para. The tribunal has failed to award any amount of compensation under the head loss of amenities, which is an error apparent on the face of the courts. In view of the facts and circumstances of the present case, where the claimant has suffered mental cognitive disability as well as neuropsychological disability, I deem it appropriate to award rupees 50,000 under the head loss of amenities. Stop. View of the above discussions, the claimant is entitled to enhancement of compensation. This one. Accordingly, as the following order. Claimant is entitled to a total compensation of dash as against 3,13,636. 8 lakh? 8,53,116 ಬರುತ್ತೇನ್ರಿ ಶಾಂತರಾಜ್?
Yes, ma'am. Yes.
As against 3,13,636. To stop. Next, all other terms and conditions stipulated by the tribunal stand intact and are not interfered. Stop. Next, enhanced compensation shall be paid, deposited before the MACT with 6% interest.
ಅಲ್ಲಿ 8% ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು, enhanced compensation will carry 6% interest. Yes, anything else?
Yes, that's all. That's all.
B. Vijay Kumar. D. Vijay Kumar. ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರ ಯಾರು ಕಾರ್ತಿಕ್ ಬಂದಿಲ್ಲ. There is no representation on behalf of either side. Hence release this matter next week. Yes, ಬೇರೆ ಯಾವ್ದಾರು ಇದೆಯಾ? Yes, Mr. Senior Counsel, busy getting ready for some matter. All well.